appeal in the matter of Faraj and Ahmad and IIB Group Holdings WLL.
Yes, Ms. Bangay.
My lady, my lords, today I appear on behalf of the husband in this appeal, Mr. Sultan, alongside Mr. Wheel, King's Counsel. He will be responding to the wife's appeal. For the bank appears Mr. Richardson, King's Counsel, along with Mr. Randall, and for the wife, Miss Faraj, appear Mr. Glazer,
Yes,
King's Counsel, and Mr. Haggie.
Yes.
Before this court today are 4 appeals or applications.
Yes.
Firstly, the husband, by his notice of appeal of 19th December 2023, appeals the decision of Sir Jonathan Cohen of 28th November 2023, and in particular his central finding that the husband had a secret bank account with a balance of some 16 million, and permission to appeal was granted by Lord Justice Moylan on 27th June 2024. There is the husband's application to adduce fresh evidence being dated 13th of February 2024, where Lord Justice Moylan, when granting appeal, directed that permission to rely on this evidence be deferred to the hearing of the substantive appeal. Thirdly, there is the appeal by IIB Bank, who I'm going to refer to as the bank, of 24th January 2024 as to paragraph 10 of the order of 15th December, which directed the terms of the purchase of a replacement property for the wife to be purchased on the sale of the former home, and that order stated that the terms were to be determined by the court, absent agreement between the parties. Permission to appeal was also granted by Lord Justice Moylan on 27th June. And fourthly, there is the application by the wife for an extension of time to appeal and permission to appeal, that application being dated 5th August 2025, by order of Lord Justice Moylan of 20th February 2026. That was listed for today with permission to follow.
Yes.
Now,
before you go on, Ms. Bangay,
yes,
would it be helpful if at this stage we give you an indication of where we have got to from a point of housekeeping and management of this rather
that would be very helpful.
I think that might be useful to all of you. Dealing with the second matter first, the husband's fresh evidence.
Yes.
We've considered, obviously, we've read all the skeleton arguments in relation to those. That is an application which we intend to refuse, in which we will give our reasons in our judgment. It's on the fresh evidence. So far as the wife's application for PTA in relation to the FAP, what we propose to do is deal with this by way of what you and counsel would all know as a rolled up hearing. Namely, we would hear submissions and determine at the end of the day whether we would grant permission to appeal. But we'd have the argument so that if we did grant permission to appeal, and there's no indication by me saying this whether we would or we would not, then we would have the material to allow to deal with the appeal itself. So application for permission to appeal with the appeal to follow if allowed. And we'd then be able to deal with that in the judgment. And I think that would allow everyone to make all their submissions about all the interwoven aspects, which is difficult for each of you to manage otherwise. I think what we'd then do, Ms. Bangay, and we will hear what you have to say, because no doubt you've had conversations about how you're going to manage who does what when, who makes submissions when. We thought if we adopted that approach, then the sensible thing would be for you, Ms. Bangay, to cover everything in one go, so as to speak, and then the bank, because obviously it's only fair on the wife given that the bank and the husband are so closely aligned in their submissions. So we'd then have the bank, and ditto, the bank would cover everything.
Yes.
Although not, she says firmly, replicating your submissions. And then we'd follow on with the wife. You, of course, would have an opportunity to reply.
Well, it will be Mr. Whale, as I
beg your pardon.
already
Yes.
indicated.
So you would divide up in between you.
That was very much his territory
Yes.
on the actual
Yes.
trial.
So, I mean, if you tag team, that's a matter entirely for you, how you manage that. It's just the principle that we would deal with everything one after another. We did try, and it's actually, I apologise for being a little late. We did try and work out a scheme before we came into court, which would deal with bits individually, and we decided we'd spend our whole time with people being jack-in-the-boxes, and so as we're very well read into the papers, it would be easier for everyone if you just went straight through.
Yes, and my lady, in terms of timing,
Yes.
Obviously it's subject to any engagement from the bench, but I would anticipate being probably some 3 hours, perhaps 4 at the most.
Yeah.
As I say, there's quite a lot, as your ladyship will appreciate, to get through. And then, I don't know, Mr. Richardson, I think, thinks he might be an hour and a half.
Possibly, my lady. Mr. Wheel will come between me and Miss Bangay.
I think the 3 hours is cumulative globally, isn't it?
Well, Mr. Wheel is dealing with the response to...
Oh, beg your pardon, yes. Yes.
So he won't come in between.
No, of course he won't.
Well, maybe I misunderstood, but I thought you indicated that if you like, Miss Bangay's team would deal with everything, then I would deal with everything, and then Mr. Glazer would deal with everything. So I'd assumed that Miss Bangay, if you like, advancing the husband's appeal, Mr. Wheel addressing the wife's permission application, then me addressing my appeal and the wife's permission application without duplicating what Mr. Wheel says, and then Mr. Glazer, and then a reply. Is that how the court was envisaging this going?
I had rather presumed that Mr. Glazer would make his application and Mr. Wheel would respond, but maybe I've misunderstood your ladyship.
Gosh, it's going to be a long day, isn't it? I thought my lady was completely clear. I'm sure we're not expecting to hear from Mr. Wheel until after we've heard the wife's submissions.
That's rather what I had
her
understood.
PTA and her appeal.
Yep.
Yes, thank you, my lord.
Yep. So going back to so you think you'll be an hour, did you say?
An hour and a half, my lady, yes.
Okay. The bank, an hour. And then the wife.
I would have thought 3 hours.
Certainly when I listed this for 2 days, I regard it's all right, you will get your go. How long do you think it will be?
I would have thought an hour, hour and a half.
Okay. We certainly, when I was listing this, I thought 2 days was a very generous, time estimate. But we will see. But if I can say, for the benefit of all of you and everyone in the room, we have each of us read very extensively into the papers in this matter.
Well, that's very comforting to hear.
When I say read into Miss Bangay, we've all looked at the transcripts, we've looked at the authorities, although I'm astonished that we have such a huge authorities bundle and virtually no authorities referred to in the skeleton arguments, but it's probably a relief. But we really are familiar with the case.
Well, then I'll be able to zip through my submissions over there.
No, well, I'm not hurrying you. I just want to reassure everyone that we're
thank you.
very well read into it.
Thank you, my lady. Whilst your ladyship has said you've refused our fresh evidence application, you'll give your reasons later, would it be impertinent just to inquire as to the sort of headline, the basis for that refusal?
Yeah, well, it doesn't satisfy Ladd and Marshall, and it could all have been with satisfied. We're not planning on hearing argument. Part of the reason that we...
No, I understand that. I'm not seeking to re-argue it. I just...
Good. We'll give you our reasons.
So, my lady, shall I move on?
Certainly. So, you'll first of all, the husband's appeal.
Your husband's appeal. My lady, by way of introduction, and just to outline the trial and the consequential, as it were, happenings, may I just sort of set the appeal in context?
Of course.
The trial took place, as as you will appreciate, between the 16th and the 19th of October 2023, in respect of the wife's application for financial remedies, her Form A having been issued 3 years prior exactly to that. As you will also appreciate, a draft judgment was initially handed down on 2nd November, and subsequent to which the husband submitted a request for clarification and reconsideration on the 6th of November, mirroring in substance his grounds of appeal. Firstly, that there'd been procedural unfairness for want of pleading or articulation of the wife's case, and that her case in particular, that the letters, that is the disputed, in respect to the disputed accounts as we've called them, reflected the true position, was not actually in fact put to the husband. And secondly, we saw further clarification of the judge's findings that there had been an event in 2020 which created this so-called fund of £16 million, about which the husband was not cross-examined. And thirdly, challenging the finding that the reports of the accountants who reviewed the IIB accounts for the existence of an account in the husband's name were tainted, as they'd not been given full access to the bank records, and which claim had not been put again to the husband in cross-examination. The judge's response was received by email on the 9th of November, and in response to that, the husband issued his application to admit further evidence. The final draft of the judgment was sent by the judge on the 23rd November for hand down on the 28th November, and the response to the husband's application appears in the supplement at the end of that judgment, paragraphs 176 to 186. And there followed after that the husband's notice of appeal on the 19th of December. As to an overview of the husband's appeal, it is against, as I've indicated, the central finding by Sir Jonathan Cohen, that the two letters written by a director, Mr. Hussain, those letters being the 20th June and 2nd November, and I presume in your extensive reading you've looked at those letters. The references are C411 and C412. Those letters which stated that the husband had funds in IIB as to $20 million represented accounts which did exist, hence his finding and then his award to the wife of some £6 million. And of course, one of which letters the husbands disclosed the existence of as long ago as November 2020 in a sworn statement addressing his finance in respect of the Family Law Act application.
The existence, but not the letter. The letter
Not
was
the
not
existence,
an
but not the letter. And again, in January 2021, in respect of the wife's application for an LSPO order, which was in fact abandoned, and which letters the husband claimed were written to bolster the bank's finances in preparations for bids which did not eventuate. Central to that finding was the 3 reports from the bank's accountants commissioned by the bank to verify the existence or non-existence of those accounts. And the judge found they couldn't be relied on as they were dependent on materials supplied to them by the husband or the bank. Thus, the husband's appeal has 2 limbs. The first is that he didn't receive a fair trial where the wife failed to articulate any conduct case as to material non-disclosure, either by pleading or by a statement in advance, nor for that matter in counsel's skeleton or in counsel's opening, in fact, counsel's skeleton specifically disavowed conduct, and reference to that is S24. And when challenged by the husband, or by myself, in fact, at the outset of the case, as to precisely what case the wife was running, further specifically disavowed that the wife was contending that the husband had any hidden bank accounts.
Well, did it? I don't think it actually said that. What it said is they couldn't point to a Swiss bank account. They didn't say they didn't.
I'm going to come to that, but it was in effect it was saying, well, not saying there's any accounts, for example, of a Swiss.
That's your interpretation. That's your submission. Is that's how we should read it?
Well, what it didn't say is we're alleging that there's a hidden account, lady. On the flip side, if it was being alleged there was a hidden account, Mr. Glaser didn't say so. The second limb to the appeal is that the case articulated by the wife to the husband in cross-examination, and we will look at the transcripts, I'm aware that you've said the court has.
Oh no, you'll take us to them.
I will take you to them, my lady. Was not that he'd hidden accounts with a substantial deposit of 20 million, but it was repeatedly asserted that the letter of the 20th of June was dishonest and a sham. And of course, he was never cross-examined, as I will come to later, on the November letter. Never, we say, during the course of the husband's extensive cross-examination over 2 days, was it put to the husband that the accounts referred to in the letter were genuine, nor was he cross-examined as to the fact that the accounts, that the source, as to the source of the funds, and nor was he cross-examined as to a lifestyle inconsistent with his stated financial position. So what we say is that the wife did not formally articulate her case that the husband had assets of 16 million until closing submissions, and that's a fact which the judge confirmed in the supplement to his judgment. So we say that the trial was procedurally unfair and that the judge reached a decision that was wrong and rationally unsupportable. I have in mind Volpe, taking into account the husband's unchallenged financial position as between 2018 and 2020, the lack of any evidence as to the source of any liquidity event that could have created a fund of £16 million, and the evidence, we say, from the company auditors who confirmed that the husband did not have and had never had any accounts with IIB containing the claimed sum or otherwise. And nor, we assert, was there a shred of evidence as to evidence of a lifestyle which reflected this claimed embarrassment of riches, and nor was it suggested otherwise to the husband in cross-examination. So I propose to structure my submissions in this way. First, I propose to address you on the legal framework relating to the requirements of procedural fairness, including the correct approach to the running of a conduct case, of which I'm sure you're aware, which material non-disclosure is a category, and how those procedural requirements, we say, were breached in this case, and also the principles relating to the drawing of adverse inferences. And then going to explain why those requirements were not satisfied, and then how the wife's case developed at trial, and in particular that it was never put to, as I already indicated, that the cross-examination that the accounts referred to in the June letter existed. Rather, it suggested that the June letter was a sham, and of course we'll come to the transcripts. Second, I'm going to address you on the second limb of the appeal, which is regardless of the breaches of procedural fairness which we allege, the judge's findings were not only plainly wrong, but were contradicted by other findings in the judgment. And those submissions will have three limbs. First, I'll set out the relevant background facts, those necessary to place in context the judge's findings that the judge had assets as of June 2020 in the sum of $20 million. Second, the evidence before the court, which we say undermined the existence of the disputed accounts. And third, the errors made by the judge, being the internal consistencies in his assessment of the facts and the application of the relevant legal principles, in particular in relation to adverse inference. So, turning first to the first ground, and of course I'm tracking our grounds of appeal, that the judge's central finding was procedurally unfair. So turning to the legal framework, and we say there shouldn't be any dispute as to the applicable principles, but because of their importance, or their central importance in the context of this appeal, it's important, I think, that I'll just highlight the key points. And we start with Crowther, which is to be found in the authorities bundle A641. That was a case where the wife had made serious allegations.
You've got a tab number.
And it's tab 18.
18.
Yes.
Thank you. I think we're all actually, to our shame, we're all working from different bundles, so if we could have tab numbers, we'd be grateful.
Well, similarly, if I have an iPad moment, I'm sure you'll be sympathetic.
Indeed.
So if we start with Crowther, and that was a case, you may recall, where the wife had made serious allegations of fraud against the husband, but she withdrew her claim shortly before the trial, and the court was required to consider the cost consequences, and the wife sought to argue that the normal rules applicable to civil litigation shouldn't apply with their full rigour to financial remedies litigation, a submission which was roundly rejected by Mrs. Justice Leven. And if we go to paragraph 58, Mr. Marshall argues that the financial remedies litigation is different from other litigation because the judge has to be concerned with the fair distribution of matrimonial assets. In my view, that is to create an exceptionalism for financial remedies litigation, which does not and should not exist. The basic principles of proper litigation conduct should apply and be enforced in the financial remedies jurisdiction as in any other. It should not be allowed to develop into a discrete world where normal principles of disclosure, pleading and discontinuance no longer apply. If a party chooses to plead fraud and then withdraws that allegation at the 11th hour, then she must expect to pay the consequences of those decisions. The principle that fraud should only be pleaded with considerable reticence if the allegation is then withdrawn and the alleging party should pay the costs on a indemnity basis, in my view, applies as much in financial remedies as in any other area of the law. So it's our submission that the court should treat the present case in exactly the same way as any other hostile or adversarial piece of litigation in which a party was seeking, we say, to change its case at the end of the trial. May I then refer to the Supreme Court judgment in TUI, that is tab 21, and go please to paragraph 36. And it is really the passage that starts 5 lines from the bottom, but it is trite law. Trite law. Do your lordships have that?
Not yet, I'll wait a minute.
Yes, thank you.
Paragraph 36, my lord.
Yep.
Page 684. And the relevant passage that I want to refer to starts 6 lines, I think, from the bottom. But it is trite law that English law operates an adversarial system, and the parties frame the issues for the judge to decide in their pleadings and their conduct in the trial. It is also trite law that in that context, it is an important part of a judge's role to make sure that the proceedings are fair. At the heart of this appeal lies the question of the requirements of a fair trial. And really the point is that the issues in the case should be framed by pleadings in advance of a trial. And by that I don't mean necessarily formal pleadings, but at least set out in evidence, and in this case in a statement by the wife. And it is important to emphasise that a judge is under an independent duty to ensure that a trial is fair. And if your lordships would please go to page 687, paragraph 42. It is the task of a judge in conducting a trial in an adversarial system to make sure that the trial is fair. It is the task of the judiciary in developing the common law and the makers of the procedural rules to formulate rules and procedures to that end. One such long-established rule is usefully set out in the current edition of Phipson on Evidence. Lord Justice Bean quoted the previous edition, which was in materially the same terms, at the start of his dissenting judgment. At paragraph 1212 of the 20th edition, the learned editor states, in general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted on that point. The rule applies in civil cases. In general, the CPR does not alter that position. This rule serves the important function of giving the witness the opportunity of explaining any contradiction or alleged problem with his evidence. If a party has decided not to cross-examine on a particular important point, he will be in difficulty in submitting that the evidence should be rejected.
So in Chewy, the claimant was not required to call his expert at all, and then in closing submissions it was submitted that he hadn't proved his case on the point
That's
that
right.
dealt with.
That's right.
And you're saying this case is similar to that one,
I'm saying that the rules that are applicable to a trial, a fair trial, are as set out here, yes. And going on, it says this statement is...
Do you want us to read the rest of the
yes,
sideline?
I'm going to go on. The statement is supported by some case law, some which I discussed below. And then paragraph 43, if I may. I'm satisfied that the statement in Phipson is correct. And as explained below, it summarises a long-standing rule of general application. It is not simply a matter of extensive legal precedence in the case law. It is a matter of the fairness of the legal proceedings as a whole. While many of the cases have been concerned with challenges to the honesty of a witness, I see no rational basis for confining the rule to such cases or those analogous categories such as allegations of bad faith or aspersions against a witness' characters as Mr. Stevens suggests. And if we then go on to paragraph 70, I was going to do this later, but it might be convenient to take the lordships to it now.
Certainly.
In conclusion, the status and application of the rule in Brown and Dunn, in the other cases that I have discussed, can be summarised in the following propositions. 1. The general rule in civil cases, as stated in Phipson, is that a party is required to challenge by cross-examination the evidence of any witness of the opposing party on a material point which he or she wishes to submit to the court should not be accepted. That rule extends to both witnesses as to fact and expert witnesses. In an adversarial system of justice...
Ms Bangay, if you're wanting us to look at the whole sideline, perhaps it's easier if we read it through.
Of course.
Just
Much
save
more
you
preferable.
reading it all.
Yes.
So
I'll leave you to it.
We'll read the whole of paragraph 70.
If you would.
Certainly. Just give us a moment. Yes, thank you.
Could I just ask, you're saying this applies directly to this case?
Yes, I am.
Who is the impugned witness?
My client.
Thank you.
Thank you.
May I then move on to deal with the issue of pleadings and being given a fair warning of the case. Whilst this court will appreciate that there is no requirement contained in the family proceedings rules for formal pleadings, in matrimonial proceedings it's now well established as part of case management in the context of disputes as to conduct and third-party property disputes and other issues of substance. And in this case, for example, the issue of the FAP and the issue of the ESOP, that pleadings, whether formal or informal, and by that I mean in terms of informal by way of sworn statement, is required. There must be evidence of the issue before the court. And that, in terms of third-party disputes, was well established in the case of TL and ML. I don't know if I need to take the court to that. And that
Give us the reference, Ms Bangay.
the reference is, it's tab 5 in the bundle, page 71, paragraph 36, where Mr Justice Mostyn set out the requirements for third pleadings in respect of third-party issues. As to the issue of conduct, this was front and centre of the issues in the case of Svetkov, and that is found in the small additional bundle of the husband's authorities. And that is tab 3, and the relevant part is to be found at paragraph 40 with the heading pleaded conduct. And in that case, the issue of the wife's conduct in a number of respects was front and centre of the case. And Mr Justice Peel directed at an early stage that the husband should set out the issues as to conduct in a formal sworn statement, so not in a formal pleading. Again, I don't know if paragraphs 40 to 46, I don't know again whether you'd rather just quietly read that, and then I can just perhaps draw the court's attention to a particular point.
You'd like us to read that now, would you?
Yes, I would.
Do you want us to read? Does that include 41 and the extensive quotation from Mr Justice Mostyn?
Yes, it does.
Do sit down for a moment, Ms Bangay.
No, I'm just missing a button. I'm looking at it online. Yeah, I'm just missing a button too. So I thought Jonathan might have.
I've got.
It's all right, it doesn't matter. I've got it.
Oh, you've got it
I've
on.
got it
Fine.
online. Yeah, no. It's not a big.
Just a bundle's gone missing, but it's fine. His lordship's reading it online, so it's fine. Are you ready?
Yeah.
Yes, yes, Miss Bangay.
Yes. So, in particular, I would like to emphasise at page 44, in terms of the analysis of the four heads of conduct, that the little paragraph 39 is the evidential technique of drawing inferences is, which is what happened in this case, is a form of conduct. And paragraph 43, Mr. Justice Peel set out in clear terms what a party asserting conduct must prove, and he sets that out, little Roman numerals 1 to 3. And then at 46, he sets out the procedure that should be followed, that conduct's a specific section 25 factor which must always be pleaded, and it must be pleaded at the earliest opportunity. And at 46.2, that party should state with particularised specificity the allegations, how the allegations meet the threshold criteria for conduct claim, and identify the financial impact, if any, I suppose, caused by the alleged conduct.
What happens, I just asked this, Ms.
Yes.
Bailey, what happens where the allegations of conduct or the material on which the allegations are based emerges during the course of the proceedings?
Well, he deals with that in here.
How do you say it applies here?
I said if he deals with that
How does that
position
apply
in here, that if
Yes.
it comes up after, during the course of the proceedings, then it is not too late, as it were, for a party to raise the issue of conduct, and the issues of conduct can be case managed.
I think his lordship's talking about if it arises during the trial.
Yes.
Yes.
If it arises during, if it arises during the hearing itself, what happens then? As a
Well,
matter
it
of
is
practice?
incumbent.
Not asking specifically, but in generally, what's your understanding of the established practice following this?
I'm not sure that I can answer that question, because if there is an issue of conduct, it's almost always raised in advance, even if perhaps the particulars can't be clarified until the party is cross-examined.
Well, that can't necessarily be the case, can it? Because if non-disclosure emerges in cross-examination, how could it be raised in advance? I think my lordship's question's aimed at when something emerges during the evidence or during the trial that demonstrates.
Yes, I'm sorry, I should have made that.
If it emerges during the trial, it is then incumbent on the party to set out the case that they would be submitting in submissions before submissions take place.
So, in other words, when Mr. Justice Peel says, as he says at 46.2, a party who seeks to rely on the other's iniquitous behaviour must say so at the earliest opportunity.
That's right.
If the earliest opportunity is in the trial, he must say so at the earliest opportunity in the trial.
Yes.
Is
But
that
that is one of our primary complaints in this case, that it wasn't until closing submissions wasn't until closing submissions that the wife articulated her case, and that is confirmed by in the judgment of Sir Jonathan Cohen. He actually says as much in his supplementary judgment.
So if it's right, I know you say it isn't right, if it's right that this whole issue in this case didn't emerge until the cross-examination,
Yes.
you say that's not right. If it's right, what happened in this case was contrary to the principle because it wasn't raised until closing submissions.
That's right.
Had it been raised earlier, you would have had an opportunity
Absolutely.
to tackle it in various ways we'll come to. Thank you.
Absolutely. Yeah. Well, also in this case, we couldn't have known that it was going to be raised because the actual case which the wife then put in closing submissions was never put to my client. It was never put to my client that these accounts were genuine, as we will see when we go through the transcripts, that it was put to my client that the letter that he wrote, that was written, was a sham and dishonest.
Well, I thought that was his own. He said that they weren't accurate letters, didn't he? That was the husband's case on the letters, wasn't it?
The husband's case on the letters in his November 20 and January 21 statement was that the accounts existed. In his replies to questionnaire, which I'm going to come to, I'll take your lordship to, it is important because in that he says the account didn't actually exist. So by February 2022, he had said the account did not exist. Yeah. So I would take your lordship through that chronologically as how it developed. I'm simply at the moment trying to establish the principles. If your lordship would find it helpful to look at that document.
Well, I think we're probably alive to the principles, but I'm not trying to deflect you from your course.
Yes.
I mean, he was asked about the letters with the different figures in and said that they were done for a different purpose and they were never true.
That's right. He was asked about one letter. The second letter, can we just be very clear? The second letter was never put to him. He was never ever cross-examined.
But you made no application to recall your client.
Well, my lady, why should I make an application, with all due respect, to call my client?
Well, perhaps because your lay client admitted that he had lied in his witness statement, which had a statement of truth on the end.
Well, my lady, he was cross-examined about that and he dealt with that. But it is not for me to call my client. It is for the wife to recall the husband to put the case.
Forgive me, I know it's unhelpful to have three different At the moment, I'm just trying to work out what you say, what is the understanding now in financial remedy proceedings about how these matters should be dealt with from a procedural point of view. That's what you're on at the moment, isn't it?
Yeah, that's what I am.
Procedural headlines. And you're saying it, and what your case is, that even if the earliest opportunity is at trial, in the middle of the evidence, then there are procedural steps which have to be gone through.
Absolutely. How can it be that one is ambushed in submissions? Why not at the end of the evidence, if that is the case that the wife was seeking to run, did she not alert us before submissions so we could deal with it? All we received was an ES2, which is a schedule of assets, as you know, an ES2 at 6:27 the night before submissions with no accompanying explanation or setting out the new case that they intended to put. It simply wasn't provided to us in advance of submissions.
And what is your case about how it should have been provided? What should Mr. Glazer have done at that point?
I'm saying.
At what point?
I will answer your question, but I'm going to say there was earlier opportunities to set out the case. But at the very, very worst, the wife should have said before submissions, this is the case I'm going to put, and Ms. Bangay will need to meet it in her submissions. Which she never did. There should have been some formal articulation, and if you're pushing me to absolute worst, by email the night before, but preferably to the judge in advance of submissions. But I'm going to, as I say, come to the transcripts later. And indeed, can I also take you to paragraph 70 paragraph 95, where this point arose when I have to put my hands up. I was counsel for Mr. Setkoff. I was roundly criticised for raising new conduct points in submissions. If you go to page 55, paragraph 95, and shall I just leave you to read that paragraph?
Thank you. Sorry, page
55.
And so, Melanie, the point is made with admirable clarity by Mr. Justice Peel at paragraph 95 that you are not permitted to raise additional conduct points.
Were the points that you were seeking to raise in that case points that had emerged in the hearing?
They were points that I was, to be blunt, instructed to put. In addition, I'm being blunt with the
We've
court.
all been there, Ms.
We've all been there, which I was instructed to put, which went beyond the pleaded conduct case.
Thank you.
So that's a little different from...
Well, they were matters which might have been arguably been conduct, but one was conscious of the fact that we had been constrained by the case management directions of Mr. Justice Peel to plead our conduct case in advance, and we didn't seek to amend that case in advance of submissions, and he roundly rejected my attempt to expand on the conduct grounds.
We did an analysis of the bank statements, I think. So that's what the judge seemed to think of.
Well, what he said is that it didn't appear in our conduct statement.
Yes, he does say that, but he then goes on the next line, three lines down, the calculation
Yes.
justifying the figure was apparently done by H's legal team, which I think was you and or others, by analysing bank
Yes,
statements, and the
yes.
analysis was not
That's absolutely right.
to you or the wife.
Yes.
Yeah. Thank you.
And at paragraph 96, he makes the point that conduct claim is specifically pleaded by reference to 6 grounds.
Yeah.
And so I was put in my place firmly.
Yeah.
So may I just say what we take from that is perhaps stating the obvious, that the discipline of pleading obliges a party only to make allegations which are properly arguable, and more importantly, perhaps centrally, they give the other party an opportunity to prepare counter evidence and legal argument to address the points made against them, and also perhaps to state the obvious, the function of a pleading is to enable the parties to know the case they have to meet in advance of the trial, and usually the FDR, because usually conduct cases are pleaded prior to an FDR, and they are all designed to avoid a trial by ambush. And it is common and a well-established practice in the family division that a court exercising its case management powers and under the overriding objective to make directions for the filing of conduct statements at an early stage, as per Svetkov, and as this court did at the first appointment. And for the court at a subsequent hearing before the trial judge to determine whether the challenge as to whether or not the conduct case has sufficient evidential basis to be pursued at trial. And if I might take the Lordship to the supplemental bundle and the wife's skeleton argument for trial, page 24 at paragraph 55, supplemented bundle 24, paragraph 55. Mr. Glazer says, in turns, one matter that will need to be addressed at this juncture, that being the question of conduct. And I pause there. Conduct, of course, includes those four heads, including adverse inference. And at the first appointment for this court on 31st December 2021, the court directed the following, and he sets out the conduct direction that was made for the filing of statements. And at paragraph 56, he says, these have not been done, and therefore conduct is not a relevant issue for the court. However, knowing this and seeking to get round this, the husband has in his Section 25 statement gone through various Section 25 under the heading of other relevant circumstances, which introduces a whole series of conduct assertions. But the primary point is that Mr. Glazer specifically referred to the direction made at the first appointment, stated no conduct statements had been filed, and that it was therefore not of relevance.
Sorry,
So,
Ms. Bangay, sorry to interrupt. Just help me on this, because of course Mr. Justice Peel's judgment, I think, postdated this skeleton argument.
It did.
And going back to where you took us at paragraph 39 of Mr. Justice Peel's judgment, talking about drawing inferences, failing to give full and frank disclosure.
Can you just bear with me while
Certainly page 44,
go back to the
44
judgment
of the husband's supplementary bundle.
Sorry, which page?
Page 44, paragraph 39.
Yes.
Just help me about this, because for my part, I wouldn't, and times change, have regarded a case of that you're putting non-disclosure as a pure conduct case necessarily requiring pleadings, that it would be answered within, be put in questionnaire and dealt with in that. But if are you now saying that actually we need to be saying that non-disclosure now is a discrete category of conduct which can only very rarely be satisfied?
Yes, my lady, this was by reference to the decision of Mr. Justice Mostyn, which was a 2020 decision.
But I'm just concerned. I'm not gainsaying you, Ms. Bangay. It's just I personally, from my experience of these cases, wouldn't necessarily have got started from the point that saying that there'd been non-disclosure amounted to gross and obvious conduct. And it seems to be that what you are saying is that it does, and therefore it should be pleaded as such.
Yes, this was spelled out.
Any non-disclosure.
Yes, this was spelled out by Mr. Justice Mostyn as long ago as 2020, and there was a direction for that reason made at the first appointment in this case, because it has been common practice in the family division where conduct is raised to make
and understood. It's just a question of what is conduct, what is going to amount to conduct is my point, Ms.
Yes.
Bangay. Of course, I accept completely that there has to be pleadings in conduct, and rightly so. But my question to you, is it your submission that, if I might call it like this, conventional non-disclosure, which is a huge feature in many of these cases if they are contested, has to be regarded by the courts as a category of gross and obvious conduct, which the full pleadings rules must apply to. Well, any allegations of non-disclosure.
Can I say yes but no but? Because what Mr. Justice Peel does is he sets out a paragraph 43 that a party asserting conduct must first set out the facts relied on, if established that those facts meet the conduct threshold, which has consistently been set at a high or exceptional level. And it is conventional now, where a party pleads conduct, that if it is, I'm coming to the point, that if it is challenged in any way, that is then determined by the judge in advance of the trial. And that, my lady, I've been involved in, I think, 2 or 3 in the recent past, where the judge then determines whether it is sufficiently grave, to answer your ladyship's question, sufficiently grave that it should go before a court.
So any allegation of non-disclosure, you say, must be identified right at the beginning and be subject to full pleading.
Well, if a party is seeking, as Mr. Justice Mawson said here, to ask the court to make adverse inferences, as in this case, that a party has hidden a substantial amount of money. You may not be able to identify the amount of money,
or where it is,
or where it is,
hunt the money,
but you must set out in clear terms what it is you are alleging. And it's our case, as you know, that it was never set out in clear terms, or otherwise the case that we had to meet. And I'm going to come to the exchange between counsel at the outset of the trial, but it's instructed, isn't it, to go to Mr. Glazer's skeleton, where he doesn't even say, well, actually there are conduct allegations, we may not have formally pleaded them, but here they are.
And that's the document you've taken us to in the supplementary bundle, isn't it? That's Mr. Glazer's opening note.
It's in the, yes, exactly. And then there's an exchange between us, which I'll come to.
I do understand that, but just to pursue the point which I think was raised a few moments ago, because I'm very interested in what your answer is. If this non-disclosure arises during the course of it, let's deal with it hypothetically, because I know it's your case that it didn't emerge like this. But certainly so far as the 2 letters are concerned, as I read the judgment, it appears that 2 letters were produced during the trial or during the hearing, which hadn't been disclosed before, which the husband is cross-examined about.
Can I stop you there? He's only cross-examined about one of them.
Yes, I accept that's what
which is important.
well, he's asked questions generally.
Yes.
So one couldn't expect or anticipate that to be dealt with in Mr. Glazer's opening, because he doesn't know about it.
Well, he does know about it.
Well, okay, let's put that to one side. That means the judge would be wrong in his description of how this unfolded, because he says that he ordered them to be disclosed and they hadn't been.
Well, Lord, the whole issue goes back to my client's 2 statements back in...
No, but I'm just talking about the trial. Just bear with me for a second, because I'm about to ask you a question in theory, and I know if something of that nature emerges during a party's witness evidence, what do you say should then be done?
I say that the wife, as in this case, should set out in advance of closing submissions the case that she is putting, but even
as
before
a conduct case, I think.
That's right. And before that, she should put her case to the husband, which
I've got that point.
I've got that point.
But so you're saying whether by way of producing a short document or something of that nature,
yes,
as well as testing the evidence in cross-examination, that should be produced by the wife in this case.
How could it be fair otherwise?
Well,
I ask the question.
it might be that the evidence is accepted by the wife. So why ought it need to be tested by cross-examination at all? And if you, I do appreciate that while I'm asking you these questions, your junior is getting somewhat bored.
Yes. Can I just
and thinks he knows
understand?
the answer.
Could you just repeat the question?
Yes.
I'm sure I
If
grasped.
the evidence that emerges in this hypothetical oral exchange from the witness is evidence that on the face of it the wife accepts or doesn't wish to challenge,
Yes.
why why should it be tested further by the wife in cross-examination?
The wife's own case in the cross-examination of my client was that the accounts didn't exist. And so if she was going to, so I can't quite answer your question directly, if she was going to put that the accounts existed, that should have been put to my client.
All right, well, let me ask the question purely hypothetically, by reference to a purely hypothetical example, so that I can get your answer to it. Different parties, different facts. In his cross-examination, the husband says, I have a collection of extremely valuable classical Ducati motorbikes. Whoops, there's the cat out the bag. And the wife doesn't, for a moment, want to challenge that he does have his collection of classical motorbikes. They've just not been disclosed. Are you saying in those circumstances the wife should then pursue that point, or is obliged to pursue that point in cross-examination, or is she entitled through her counsel to think that's very useful evidence in favour of my case, I'm going to leave that right there?
Well, first of all, you want to know, you say very valuable, you want to know the value of them. If it was me as counsel, I'd be saying to the judge, well, I would like to know the value of these, and clearly these need to go into the pot, and I will be submitting that they are in the pot for the purpose of the distribution exercise, because that is part of that's the computation. So yes, you would have been clear and upfront, saying I want to know the value, these must go into the pot.
You'd like to try the motorbikes out, wouldn't you?
Well, I would, of course, for another day. So that's the way you would deal with it, if you're asking me hypothetically.
I know it's hard having different angles, but I'm intrigued by this, what Milady's, following up Milady's point. It seems to be a development of what is understood about conduct. Now, it may well be, this is now well established in the family division, but conduct under the Act is defined as conduct which it will be inequitable to ignore. And I thought the conventional purpose of looking at conduct under that heading was to adjust the division of assets because of the conduct. Conduct now here is defined to include non-disclosure.
And add back.
And add back, but not to those, but on non-disclosure, the point of pursuing non-disclosure is in order to understand the extent of the assets.
Oh yes.
So that's a different exercise.
Well,
and it's an exercise which often involves pursuit in cross-examination and argument and repeated applications for disclosure. But you're saying that this is nonetheless a matter which has to, on these authorities, has to come within this formalised, more formalised structure because of the expanded definition of conduct.
Well, it's certainly been my understanding as a practitioner, since it was spelt out by Mr. Justice Mostyn, that if we are raising the issue of conduct under those four heads, that we are obliged to set out, whether by formal pleading or otherwise, because the family proceedings rules don't make any provision for that, it's what is developed under various case law, all intended to make sure that when you get to the trial, you know what the issue is.
But there is a difference, isn't there? Because conduct under the narrow sense, as it was previously understood, i.e. conduct which it would be inequitable to ignore, relates to conduct during the marriage, which the party alleging it is going to say should affect how the assets should be divided, allocated. So that's something which is going to be possible to plead at an early stage. Violence, coercive control, etc. Here, we're talking about conduct of a sort which will inevitably, well not inevitably, but in most cases, the details of which will only emerge in the course of the proceedings, and, Mr. Glaser would say in this case, only emerged at the moment in trial.
Well,
but nonetheless, you say it's something which has to go through this formalised process on the authorities you cited.
That is the basis on which we as practitioners have operated on, that if you are raising conduct, it has been said time and again, you must do so as Mr Justice Peel says, at the earliest possible stage. And we say the earliest possible stage was the first appointment, by which time, number one, my client had made the 2 statements he had, and number 2, by the time the first appointment order was finalised in March, he had provided his questionnaire replies, which said, actually no account.
But this is going to lead, this does open up arguments about whether the point can be taken. Because in contrast to conventional conduct issues, where the conduct happened during the marriage, so it's all known about, here there's going to be scope for all sorts of arguments about when the earliest opportunity was. That's the point you're taking in this case. But nonetheless, that doesn't matter,
well,
you say.
There could be all sorts of arguments about when the earliest opportunity was, but it's certainly before a trial, and usually at the absolute latest in the wife's Section 25 statement, which is the point I made to Sir Jonathan Cohen, that there was no advertising on or particulars relating to the alleged non-disclosure. We'll come, as I say, to the wife's statement in a moment. But what you cannot do, in my submission, is wait until the final submissions. And I would just like to remind the court of the judgment of Mr Justice Cohen on this point. Where he says in his supplemental judgment at page 95 of the core bundle, page 182, in closing submissions, the wife made clear what she was seeking and her reliance on the letters. And then we were criticised, say, the second part of that sentence, the husband didn't seek to reopen the matter either then or in the 6 days for receipt of the draft judgment. So the judge implicitly accepted that the wife had not made out her case until the closing submissions.
Well, I think, if I say so, one has to read 182 in the context of 180 and 181. And that's where he deals with the point, isn't it?
Yes.
He says it's always been the case that he's been worth millions.
Well, yes, but if you are going to plead that he's worth millions, you must be able to point to how he's worth millions. And one of the matters that I'm going to deal with is what possible liquidity event could there have been. As the judge himself said in the judgment, it's a matter of surmise. And if the husband doesn't have the money, well, that's tough, is what he says. So, what I say is that it's a matter of practice in the family division and formalised effectively by Mr Justice Mostyn in 2020, if not before, and then reiterated by Mr Justice Peel in the judgment of Setcol, that first of all, there are these 4 categories of conduct, of which adverse inference and also add back. The point your lordship made to me earlier, I mean, adverse add back, you might not say is great and obvious, but it still has to be pleaded. And the court has to have some grasp of what it is the wife is alleging should be added back.
Can I just, and this is a very short, brief point of clarification, the letters which he's explaining in 182, in the judgment,
yes,
Cohen J at 182,
yes,
her reliance upon the letters,
yes,
just to be clear for my own purposes, those are the same letters that he explains in paragraph 89, is that right? Of his judgment on page 89.
I can't remember paragraph 89
Well,
off the top of my head.
I'll just give you a moment.
Just give me a moment. Yes.
Those are the same letters.
Those are the same letters. Yeah. The letters that you find in the core bundle at page 411 and 412.
And So when he says they appeared as late as days 4 and 7 of the hearing,
Yes.
that's correct, is it?
Yes. Just to give your lordship some context, day 1 was a reading day.
Yeah.
Day 2 was opening and the wife giving evidence. Her evidence slipped over then into day 3, and it was my client, I believe, and I'll be correct if I'm wrong, started giving evidence on day 4.
That's fine.
I think that's how it worked, my lord, but I'll be corrected if I'm wrong. So, my lord, I think I've dealt as comprehensively as I can with the issue of pleadings. And then what we say is, independently of pleading, and it really follows on from some, I think, the questions that you have asked, by way of belt and braces, it is a fundamental principle, we assert, that in order for there to be a fair trial, a party must have fair warning of the case against him. And can I take you, please, to the authorities bundle and Zuckerman, which is at tab 25. And we just, and perhaps I can invite you to read the passage at 3179 through to 3182, which commences the general principle that each party should be given a reasonable opportunity to know and challenge the case against them and present their own case long established. 3179 through to the end of 3182, pages 794 and 795.
Thank you.
So really the key point is that a party must have a fair opportunity to respond to evidence and arguments made against them. And generally, as I've indicated, that's done through pleadings, whether formal or informal. And it's our primary position in the present case that the wife had a fair opportunity to obtain all the relevant evidence in respect of her claim. And if she'd wanted to advance a claim in advance of the trial that there was a missing account, it was incumbent upon her, if not to plead it, to set it out in her evidence, and at worst her section 25 statement. And may I just take you to what she actually said in her statement, and that's in the supplemental bundle at page C, oh, I'm so sorry, the core bundle, forgive me. Core bundle, page 166. When she's, 166 paragraph 49. This was, as I said, the only clue that we had about what the wife was saying. I shall leave my legal team to make further submissions on this at final hearing. Needless to say, I believe Sahil has extensive resources and that he can access funds from IIB. he is painting a deceptive picture to the court. So that was all the wife particularised in advance of the trial. And
you read paragraph 51. Sorry, could I ask, sorry to interrupt, paragraph 51 as well, whilst we're on that page. Thank you.
Certainly.
So there was no particularisation of what the wife was saying to my resources. And this feeds in then to what Mr. Glaser said in response to my complaint at the opening of the trial, but I'll come back to that. So to take your Lordship's point, we recognise that in some cases evidence may emerge during the course of a trial which couldn't have been foreseen. But even in that situation, it is incumbent upon the party who wishes to advance a new case, A, to put it to the husband or the wife, and B, to raise it with the judge, so that, if need be, procedural steps can be put in place to give the other party, the other party, a fair opportunity to address it. All the more so, as I say, in this case, because we had raised at the outset our objections, the fact that we didn't know what case that we were meeting. Then can I then turn to the facts relating to these disputed accounts and how we say procedural requirements were breached. The husband disclosed the existence of the June 2020 letter in his statement in respect to the Family Law Act proceedings. And of course you are required, when responding to a Family Law Act application, to set out a summary of your financial position. And if we go to the core bundle, please, page C231, yeah.
Give me a
Yeah,
moment.
it's paragraph 231, it's page 109. The only other meaningful bank account I have is an account of one of the subsidiary banks which IIB owns. Although this has previously showed a sizable deposit in excess of several $1 million, this is effectively a blocked cash account. What that means is, on the books of the bank, the account in my name was credited with the money, but the cash balance in the account can never leave the bank. The reason for this was twofold. Firstly, it simply has received certain regulatory reporting requirements in respect of gross deposits targets, and secondly, it allowed us to present the account as reflecting sufficient funds to support a bid we made to acquire another bank for one of our banking subsidiaries. In practice, the account balance is zero, as it does not represent cash which I could ever withdraw. On the books of the account, there is an asset, brackets cash or cash equivalents. On the liability side, there is the offsetting deposit. And then the critical passage. Myrna has in the past asked about a letter from the bank setting out the deposit balance, and I had explained the above to her. She may simply believe that this is not true, and that in practice I have several $1 million offshore, which may be her motivation for bringing divorce proceedings. Whilst we have unnecessarily struggled financially, nothing could be further from the truth, and if this is what she's based her financial relief claims on, she will find that there is no cash. So this was a document which was raised by my client. That's the irony, in effect, of the situation, that he brought it to the court's attention. And then if we go on to his second statement, which was filed on the 21st of January 2021. It's effectively a repetition. It's at page... I think, forgive me, I think, yeah, here we go.
Page 125, perhaps?
125, yes.
Paragraph 93 is my note.
Yes, paragraph 93. Whilst Minna has not raised this in her statement, as it was exposed that she is in receipt of imam documents, she has in the past asked me about a letter from the bank setting out a deposit balance in my name. I explained to her at the time that although the account's previously shown a sizable deposit, in excess of several $1 million, this is effectively a blocked cash account. What that means from the books of the bank, the accounting money that's credited with the money, that the cash balance of the account was never paid into the account, therefore is nothing for the bank to pay out. Effective deposit is zero. And then it's effectively an identical explanation as to the one he set out in his first statement. Now, subsequent to both those statements, the wife filed a certificate of complexity. It's not in the bundle, but she claimed in that certificate of complexity that the husband was worth tens of millions, and it was a repetition of claims that she had made for the Family Law Act, in her statement, the Family Law Act proceedings. Then in her Form E, again that's not in the bundle, I can tell your lordships that the conduct section was left blank. There was no suggestion in that there were hidden resources. That was dated 23rd.
Was there any suggestion elsewhere in the Form E that there were hidden resources?
No. And then as to the husband's Form E, this the wife probed by way of an extensive questionnaire, which your lordships will see is in the bundle, and he comprehensively answered it. And so the wife had a full opportunity to pursue matters, whether through further questionnaires or
Where does he deal with the letter in this account and the questionnaire?
Going to take the ladyship to it.
Thank you.
Right now, you took the words out of my mouth. If we go, please, to C152, core bundle.
Sorry, 152.
Sorry, supplemental bundle. 152.
Yep.
And I simply observe that his replies to the questionnaire were some 50, as it were, pages long. So it was a very, very extensive questionnaire, and I think the documents exhibited to it ran to, I think, some 2,000 pages. So here he's asked about the account in the centre of the page. At paragraph 231 of the respondent's first witness statement in the Family Law Act proceedings, he stated as follows: the only other meaningful bank account I have is an account with one of the subsidiary banks which IIB owns. Although this has previously shown a sizable deposit in excess of several $1 million, this is effectively a blocked cash account. And then the question, please identify the account and provide copy statements from the date of the account's opening to the date of answering the questionnaire. So can I just pause there? There was no request for the letter.
Well, he was obliged to disclose it. It was highly relevant.
Well, he didn't have the letter, my lady.
He's a 60% shareholder. He can get access to the letter, as he did when, during the course of the trial, the judge told him to.
No, I understand your ladyship's ire at the point that I take, but he wasn't. The simple point was, if the wife had thought that this was an important document, she would have asked for it. And secondly, my client understood, by reason of the fact she hadn't asked further questions about the letter, that she recalled him discussing it with her and accepted his explanation as he had set out in his statement.
I haven't got it to hand, Ms Bangay, but I have read through all the directions and all the orders. And there is the conventional order somewhere, which you'll be able to take me to, I'm sure, where he's told he has to disclose any documents, including those that are adverse to him.
That's right.
So why didn't he disclose the letters?
But it was not in his possession. As your ladyship probably collected at the trial, the letter was produced by Mr. saying my client had thought he had left it at the family home. It didn't appear in any documents disclosed by the wife, and it did not...
So his excuse is, I didn't have it in my possession at that very moment.
Well, my lady,
so
I don't
failure
think...
to disclose a document that was clearly adverse to him, notwithstanding his role in the bank, he said, not my problem.
That's his explanation, my lady. Your ladyship terms it an excuse. But he was only asked in this questionnaire to identify the account and provide copy statements. And what he says is that the blocked account referenced in the respondent's witness statement was a voluntary explanation of the financial accounting entries created in support of the group's bid for Banco Commercial Banco, and it is not a reference to an actual account. The group's external auditors or their banking subsidiaries were asked to undertake a special review and issued statements stating that A, no accounts exist, B, no accounts had existed since these banking subsidiaries were acquired, and C, subsequently no SWIFT payments have been made receiving or transferring deposits in the respondent's name or the name of any company related to him. And the respondent produces the letter of confirmation from the group's auditors, as well as the statement from the CFO. Now, lady, I don't wish to make you more cross, but Mr.
Amused and not cross, Ms Bangay. So just the CFO's witness statement, just to clarify before you expand, that's Mr Hussein's witness statement that he accepts was a lie.
Yes.
Thank you.
Before could I go back to a little point you made a minute ago?
Okay.
You say, one of your criticisms of the way in which the case has been advanced on the client's behalf, you say there was no reference in the Form E to this allegation of conduct.
Yes.
But unless I'm looking at the wrong version of the Form E, the blank Form E requires a party to set out bad behaviour or conduct by the other party will only be taken into account in very exceptional circumstances when deciding how assets should be divided, should be shared after divorce or dissolution. If you feel it should be taken into account, identify the nature of the behaviour or conduct below. Doesn't that focus conduct on the narrower sense that I was referring to earlier, conduct that would be inequitable to ignore when dividing the assets, not conduct in the broader sense that you're submitting is now required by virtue of Mr Mostyn's judgment?
If you take the word literally, I can't disagree with the Lordship, but in practice, if there are conduct allegations, it is that box in which they are set out. Whether it is marital conduct, litigation conduct, adverse inference, or non-disclosure.
So that's how it should be understood by all parties, is it?
I'm so sorry, Madam.
That's how it should be understood by parties, including unrepresented parties.
I can't argue with the literal wording, but if you are raising conduct...
I'm sure you can.
As well as Mr Justice...
Wouldn't put it past you, Miss Bank. In fact, I think that's what you are trying.
Whether that's flattering or not. If you go back to the judgment of Mr Justice Peel, may I take you back to what...
No, I follow the point.
He says that you must raise conduct in your Form E, or when it arises. So it is commonly understood, even if the literal words don't say adverse inference, etc., it is commonly understood that that is where you raise your allegations of whatever variety.
I can't remember, is there anything in a Form E where you're supposed to say where you think the other party have not are not disclosing assets?
No, that's why I'm saying.
That's why I say it's got to go somewhere. It's got to
Yes, that's the kind of the global, it's the global heading for, as I say, per Mr. Justice Peel, that he says where you should raise it. And what he said also you shouldn't do is reserve your position.
Okay.
Right, so we've got the 2 witness statements, we've got the Form E, we've got the questionnaire. Where are we going next?
Right. So I make the point that, as I say, I'm not sure the relationship's going to accept it, but that he had no reason to believe that his explanation that no counsel ever opened was not accepted, and that the explanation he had set out in his statement that he'd discussed and explained this to his wife was accepted. There was no suggestion to the contrary in any statement filed either in the Family Law Act application or in the LSPO application or subsequently. And if the wife believed that the husband had a bank account that he had not disclosed, why was that issue not first vigorously pursued or pleaded, either in I'm using pleading in the widest sense, why was it not pleaded at some point in a statement? And pursuant to the conduct directions, which were made in December but formally concluded in March 2022, by that time the wife had the husband's replies to the question, and perhaps I can just take you to the order that was made. That is in the bundle, it commences at page 539.
Just remind me of the dates. I've got the orders separately, so just give me the date of the order again.
It's paragraph 25, my lady.
Is this the substantial directions order of the
Yes.
15th of December?
So what happened was there was a first appointment. There was disagreement about what directions had been made, and there was yet a further hearing to address those directions on, I believe, was it the 3rd of March? Yeah, the 2nd of March.
Of 23.
2022.
Oh, right.
Oh, do I have
Yes,
that?
I have it. Order.
Yes, you have it.
Yep. Thank
Yeah,
you.
I think you gave us a page number 539.
Yes.
All right.
Yes, I did, and that's completely wrong.
No,
I take it back instantly. It's page 544. The order starts at 544.
Of which bundle? Sorry.
I think it's the second supplementary bundle.
Yes, I think you're right.
I have it
Somewhere else.
in the core bundle.
You're very lucky, but I haven't.
534.
But I've got it anyway. 544.
44.
And you want us
Yes,
to
the
look...
order starts at 539. It's the statement that deals with conduct is at page 544.
Thank you.
And so we were conscious, if I can say that, because of the way the wife had run the Family Law Act proceedings, that she was saying there were assets that hadn't been disclosed or resources available to my client. And it wasn't Mr. Glazer at that hearing, it was the wife was represented, if I remember correctly, by Mr. Todd, King's Counsel. And so there was this provision for statements for conduct. And just to take your ladyship's point, this was, of course, before the judgment in Speckhoff, and it was simply following, as it were, the convention in the family division for statements to be filed for conduct at the first appointment if it was to be an issue. And so at paragraph 25 it says, in the event that either the applicant wife or the respondent husband seeks to run a conduct case, and then it makes provisions for the filing of statements stating what conduct exactly they seek to rely on, the basis for their conduct allegation, and what effect this alleged conduct should have on the current financial remedy application. and then the parties have permission to send the court serving the other party's statement in answer. And the whole purpose of this was to have any conduct issues on the table before the FDR, as you can see. And at the same time, there was, of course, the issue raised about the ESOP and the VAT, as you can see in the recitals. Page 540. And that was where the bank were joined as party to the proceedings.
Yep.
And at page 542, there were directions made for the pleadings. So the wife didn't file any conduct statement, as you know, and neither before the FDR or at the PTR, which took place in July 2023, had she formally or informally raised or pleaded any allegation to the effect that she'd seen the June 2020 letter and did or did not accept the husband's explanation, nor did she assert there were accounts or any other monies or assets held within IIB which belonged to my client, and nor did she mount any challenge to the letters of instructions to the accountants or the accountants' reports, which of course had been provided to her in February 22 with the husband's replies.
Just help me this, I just can't remember off from the transcript. So the husband obviously in his witness statement said that he presumed that the wife had seen through the imminent materials the letter.
That was in both his statements.
In the 21 and
the
yes,
20 and 21 statements, yes.
Now, was it put to the wife in cross-examination that she'd seen the letter, or has she at any stage in the proceedings agreed that she has seen the letter?
No,
or is it's just the husband's allegation or presumption that she must have seen the letter?
It was never raised by the wife at any
No, I'm asking about the husband's case was that she'd seen the letter. I'm just asking if that was put to her.
No, because it wasn't gainsaid.
I'm
It was,
not saying whether he should.
From our perspective, it appeared to be accepted. His explanation, both spelt out in November 20 and January 2021, allied with his questionnaire replies, seems to have been accepted. And it is also a point worth making that the wife filed a schedule of deficiencies in respect of my client's questionnaire, but asked not a single question in there either about the letter or the accounts. The issue, as it was never raised, or you might say raised again, after my client's replies to questionnaire.
Was the letter disclosable by your client?
Had it been in my client's possession, yes.
And are you using possession in the very narrow sense that he had to have it on him, or that he could get it?
That he could get it, my lord. As I said, he had thought he had left it in the family home when he was summarily evicted from the property, and Your Lordship knows there's a whole issue about Immerman documents, and my client had thought it was within those documents, but
was it disclosable as a document a relevant document which we had but no longer had? Is it disclosable in those circumstances in line with family procedure rules?
If he didn't have it, then he couldn't produce it.
Well, you did just say to my lord, or just phrase it, if he could get it, and he clearly could get it.
What, Lady, he didn't know that it was relevant, and in retrospect, if he had been asked for it, of course, he would have produced it And if he didn't have it, he would have asked Mr. Hussain for it, and it was in Mr. Hussain's possession.
Thank you.
But that doesn't detract from the fact that there was no allegation made by the wife in respect of that letter, and no further inquiries after my client's questionnaire replied back in February 2022. The only allegations which, that's obvious to your lordships, that the wife sought to pursue and articulate through pleadings were in relation to the fact and the ESOP. If there had been any hint, any indication at the many hearings that we had, the wife wished to make a claim in respect of the accounts, then there would have been further directions for pleadings, by way of statement or otherwise, and the husband given an opportunity to address any concerns. And if we turn to the wife's skeleton for the trial, and that is in the supplemental bundle, if you go to page 3 of the supplemental bundle, and I draw your attention to paragraph 2 and 3. It's the wife's case that the husband has manifestly and significantly failed to disclose the true extent of his assets and resources, and that the court will not be in a position fully to work out what they are with precision. It's further the wife's case that the documentary record that the husband has provided to evidence his case on A, the fact, B, the value of the bank, and C, the FAPMT, and D, his shareholding in the bank, are artificial and misleading. Extensive pleadings and statements have been made. We will not use this note to deal with issues that are manifestly now a matter for cross-examination. We will see by the end of this hearing the husband has more than enough to meet her open offer and his own needs. And so, other than, as I took your lordships to earlier, the paragraph 55, where Mr. Glaser referred to the statements dealing with conduct and saying it wasn't a relevant issue for the court.
That's the one at page 22, I think.
That's right, page 24. And I should also remind the court that under his heading of non-disclosure, under the heading of some law as to non-disclosure, there is then an 8-page extract from the decision of this court in Moha. So effectively, what we say is that the wife was disavowing conduct, but on the other hand, making vague, and I do say they're vague, assertions, because they were unparticularised, that my client had undisclosed resources. And such was the position that I challenged Mr. Glaser in the opening submissions, and if I can take your lordship to the transcript. It's at page page 199 of the supplemental bundle, line 22. Again, if your lordships have read extensively this part of the transcript. I'm simply going to highlight what I think is most important.
That's helpful, thank you.
Which was effectively the last line at page 28-29. When I say that we are in the invidious position that I'm about to cross-examine the wife, and I don't know what her case is.
Sorry, this is page 199.
199, line 20.
Got it.
Starts at line 22.
Sorry, thank you.
But if the point I want to emphasise is line 28. Which is, I don't know what the wife's case is. And I took his lordship through, first of all, the wife's statement, as you can see, then Mr. Glazer's note, which I referred to, and then, of course, the requirements for the findings of adverse inference. And it's, so then we go to page 202. I'm going to leave your lordship to read 199 onwards. So page, line 10, I say, so I, on behalf of my client, am at a loss to know whether these alleged hidden assets are hidden. No positive case is being advanced, and it tends to suggest, and sorry to get from Moher, that this is based on speculation, other than to, and I don't know what that word is, which I understand, but for Mr. Glazer to say repeatedly, and his client said, well, there are hidden assets, Lord, I need to know what their case is. I need to challenge that case when I cross-examine the wife. And so Jonathan turns to Mr. Glazer and said, well, is there anything beyond the resources of the father? Mr. Glazer says yes, or the company said yes. And Sir Jonathan says lifestyle, question mark. And Mr. Glazer says this, lifestyle, question mark. I don't know what the next word is, question mark. Some of the cross-examination we're going to hear, question mark, people do leave things off for me. That's why we have trials and judges. I'm sorry that Miss Bangay feels disabled. My client is not going to be able to position to say, there's a Swiss bank account, a Swiss bank. Some cases you do, some cases you can say, there's a Swiss bank account. We always went to Switzerland. We removed a suitcase full of money and went shopping, and it's not on your Form E. There are those cases where parties live a particular lifestyle, and all you can give is evidence of a particular lifestyle, and it's influential. This is a case where the court is going to have to hear the evidence. Ms. Bangay, for my part, in her Section 25 statement, doesn't say, I saw a Swiss bank account. She doesn't say, he used to come home with suitcases full of money. So she can't give apart from, I think it means can't give evidence, apart from what she's put in her Section 25 statement and other things, any direct evidence. So Ms. Bangay can cross-examine her on the evidence of fact that this witness of fact is able to give, and I will cross-examine her client and Mrs. Sable with us. And so Jonathan said, well, Ms. Bangay, I think I've just got to see how this develops. I recognise there is a potential for your client to find himself in a position where he is embarrassed, but he's not, because he is not going to be able to call the evidence that he might want to. But I think I will have to deal with that when and if it arises. And I go on, my lord, I take your point about getting on with it, but I do say with some force that Mr. Glazer has been given an opportunity by your lordship now to set out what he says are the hidden assets. And so Jonathan, well, I think there are cases where it is easier to say that than in practice. I fully recognise that my findings have got to have a solid evidential basis. I shall not overlook that, but I think we need to see how the evidence develops. So there was, as you might expect, a protest at the outset of the case, because I simply didn't know what case the wife was putting. I understood that it was to do with the resources of the father. I was told it was about lifestyle, though my client was never cross-examined at all. about that. But in terms of pointing to any account, and in particular the IIB account, there was no mention. And if the accounts had been an issue, it would have had a material effect on the questions that I would have asked the wife in cross-examination. For example, do you recall the husband showing you a letter in or around 2020 which showed he had a number of substantive bank accounts? Question, do you recall him discussing this letter with you and explaining why the letter had been written? Do you recall his explanation that these accounts did not exist? He filed 2 statements in November 2020 and January 2021 referring to a letter, and you did not respond in respect to the existence or otherwise of the accounts. Was it because you accepted his explanation? And so on and so forth. So there would have been, had I been put on notice of that, those are the questions that I would have asked the wife, whereas the focus of the cross-examination of the wife was to demonstrate the husband's lack of resources.
How would those questions have affected questions of your client's credibility?
Oh, God, I have to think about that. How would they have affected? They would have corroborated, would they not, his evidence that he had set out in his November 2020 statement.
Not quite, because in the statement he said the accounts existed and money had been transferred to them. And now he was saying that accounts never existed at all.
You're quite right, can I qualify that? It would have corroborated the fact that he had showed her the letter, that they had had a discussion about it, and that she had accepted his explanation. Or be it that his explanation, as we know, in part was a lie. But critically, it would have shown that he had discussed it with her, which of course I didn't put because I didn't know it was an issue. So those are the questions that I would have asked the wife.
But one of the questions you say you'd have asked her, do you recall his explanation that these accounts don't exist? That directly conflicts with, as she would have understood it at the time, what his written witness evidence was. So you couldn't have questioned her then, could you, on an account?
Sorry, can you say, sorry.
Yeah. You have taken us to his written witness evidence
Yes.
about these accounts, which say on their face, I know they were then explained in the Form E responses, that an account existed. So how could you put to her in her cross-examination, do you recall his explanation that the accounts don't exist? Because at that point...
No, do you accept the explanation that because he put in his replies to questionnaire that the accounts didn't exist? So then...
Well, you told us, I think, that those replies were done by Mr. Hussain.
No, the replies to questionnaire were by my client.
So on the face of his Form E answers, he's saying 2 things. One, they did exist, and then they don't exist.
Sorry.
Is that right?
In his Form E, they weren't referred to because the accounts didn't exist. He referred to them in his 2 statements, and then he, as it were, corrected the position in his replies to questionnaire. Can I just take you back to those?
Well, if you...
Page 152 of that bundle.
Yeah, it's that bundle that I'm slightly puzzled about, because I can't quite track which bundle it is.
Core is his witness
It's
statement.
the core bundle, my lord.
And it's paragraph on 152.
Yes,
Paragraph.
152.
Paragraph.
And it's part of a 50-page
Yes. Reply.
response. And they were filed in February 2022.
Which paragraph? I'm sorry. Which paragraph again? In that.
I took your lordship's it. It's the question at G in the centre of the page, commencing at perhaps...
I don't think that's...
We're not on the right page.
Oh, I'm so sorry.
Supplement.
It's not...
I'm so sorry. It is, as
Supplementary.
Mr. Wales has kindly reminded me, the supplemental bundle.
Miss Bangor, I think we're getting in a muddle here.
No, it's fine. I'm muddling.
You told us, when you were helpfully giving us some examples of how your cross-examination
Yes.
would be different. So,
Yes.
And a point that was picked up by my lord was you were saying you would have put to her that you knew because he'd explained to you that there was no such account.
Yes.
Now, I think certainly my question, and I think what my Lord Justice Fraser was concerned about, was in the witness statements, the husband said that he had explained to the wife not that they did not exist, but that they were a blocked account showing sizable money
That's right.
in his name. So I think my Lord Justice Fraser's question was, how could you possibly have cross-examined the wife saying he explained to you they didn't exist, when his own written evidence before Sir Jonathan Cohen was that that was not his explanation that he'd given his wife. The explanation he'd given to his wife that they did exist, but that it was a blocked account.
I would have put to the wife that she knew and accepted that there was no actual money, whether those accounts existed or not, that they didn't mean that the husband had, well, we called it loosely $20 million, the judge found.
So you would have put to the wife, she knew perfectly well that there was no money.
Exactly, and as we had set out in our replies to questionnaire, and it had never been challenged, not a single question or
Well,
issue.
we have that point. You
Yes.
told us that. I mean, it's an important point. We've noted it. I'm not saying we're disregarding it, Miss Banky. I'm just saying that we have the point.
So and if your lordship had extensively read the transcripts, including the cross-examination of the wife, you will see that the whole purpose of the thrust, if I can put it that way, of the cross-examination of the wife was that the husband didn't have any hidden resources. And it was that in 2018, 2019, he was hard up. He'd had to borrow the monies to extend the lease, and the wife knew that he borrowed them from the bank, that the wife knew, and she accepted she knew, that he borrowed monies from friends, and that she accepted that the only purchase, this is an important point, that the only possible source of funds for the purchase of Thurlow Square, you appreciate the property he was trying to buy for the family in the summer of 2020, was either borrowing from the bank or Mr. Horse Akbar paying up.
So the thrust of your cross-examination was that she knew he didn't have any money.
That's right. That was right. And
So you could have asked her about the letter in that context, because on your case, which you knew about, she'd seen the letter.
look, I hadn't seen the letter. I had never seen the letter.
But he refers to it in his statements, as you say.
He does, but I had never seen it. I had asked my client right back at the beginning, as I recall it, because I was his counsel at the Family Law Act proceedings, where is this letter? He said he thought it was in the home. Why would I asked rhetorically, ask questions about a letter that wasn't apparently an issue, not raised in a single statement of the wife, or raised by Mr. Glaser in his skeleton, or averted to when challenged about what the issues in the case was. The whole thrust of the cross-examination was to confirm with the wife that she accepted, which she did, that she could point to no other resources. She herself did not point to the letter. Had she pointed...
But we don't know if she knew. But, I mean, it was just your late client's assertion that she'd seen the letter. It was never put to her, so I don't know, and I'm not asking whether she'd actually seen the letter.
Well,
we don't know that.
I understand, but it wasn't gainsaid by the wife. There was no response in the Family Law Act proceedings or in the LSP application. Well, I've seen this letter, and I don't accept it. She has never once mentioned it. So you can press me as hard as you like about the letter, but it wasn't on the horizon. Had it been raised in Mr. Glaser's skeleton, of course I would have asked questions about her. And of course I'd have taken my client in chief and asked him to address that. Of course. But it wasn't an issue.
Okay, thank you.
The crucial point, the court may or may not agree with me, but certainly from our perspective, was that the wife's counsel was expressly stating that it was not her case that there was a hidden bank account, whether in the bank or elsewhere. I mean, to be using the Swiss bank.
Was he expressly saying there was not a bank account?
No, what he said was that there's never been any suggestion, and he used by way of example, he would say, a Swiss bank account. He's using that phrase to describe any form of undisclosed bank account. If he was going to suggest that there was any undisclosed bank account, why not say so?
I read the Swiss bank account reference as typically colourful rhetoric from Mr. Glaser, rather than any specific disavowal of there being a bank account.
Yes, well, as I say, I listened to it, or I received it in the wider context, because if he was going to assert that there was any hidden bank account, that was his opportunity to do it.
I think you're, with respect, and I'm putting myself in a measured way, not necessarily following the Swiss bank account submission. You have taken us to the part where you identified to the judge what you said was a lack of particularity on the hidden assets.
Yes.
And his explanation involved his allegory about a Swiss bank account.
Yes.
Ergo, in some circumstances, other clients might go to Switzerland and they might be able to say X, Y, Z, so they could say there's a Swiss bank account. Are you saying we should read that as disavowing any case on any hidden assets?
Well, yes, I said that for 2 reasons. One, that was how it came across, as it were.
Understood.
And two, if he was alleging there was an undisclosed account, that was the time to say it.
Well, for my part, I read what he's saying there as saying, I can't point to any assets because it's not like a case where the wife went with the husband to the Swiss bank account, they took a lot of money out and went to spend it on a flash holiday or whatever he said.
Yes,
He's saying I can't point to anything, but I'm still saying there are cases there are hidden assets, isn't he?
Well, yes, but
You just
he
can't point to-
had both the husband's statements about the accounts for some 2-3 years before the trial. If that was an issue, put it in the wife's statement. Put some evidence in. Plead it. Put it in your opening. And when challenged, explain that issue. But it was not, as I repeat, and I can't say it too often, it was not an issue that came to the fore until my client was first cross-examined on the first letter, and of course he was never, ever cross-examined on the second. I mean, if, as I say, if the accounts had been an issue, it would have had a material effect on the questions that I've asked the wife, and I've given some examples of the sort of questions. And the judge accepted that the wife was very vague about her assertions about resources, which is why the entire thrust of the bulk of my cross-examination was driven to establishing that she accepted that she could point to no resources. I'll come to the questions that were put to the husband and Mr. Hussein in their cross-examination in a moment, but we submit that on a fair reading of the transcripts and the evidence filed in advance of the trial, that it was never made clear by the wife before her closing submissions that it was her intention to advance an entirely new case to the effect that the disputed accounts were real and represented money freely available to my client. And the wife did not seek to amend her pleaded case, and again I use that in the widest context, or properly to articulate, either orally or in writing, what her case was in respect of the disputed accounts. And the first indication we set out, I think, in our skeleton was an amended ES2 served at 6:27 p.m. the night before submissions with no accompanying explanation, and after the close of evidence and before the husband was to give his submissions the following morning. And may I, before I deal with the cross-examination of the husband and Mr. Hussain, may I just ask your lordships to go to the judgment in the court bundle at page 95. And just really make the point that in our submission the judge was wrong to have made the assertion he did at paragraph 180, where he said it's always been the wife's case, the husband was worth millions. She was not obliged formally to plead specifically that H had accounts holding such sums, as the pleadings were ordered in the matters which involved the rights of the intervener. She didn't have the letters and was not aware of the contents. Well, I accept the latter part of that sentence, that he specifically averred, and I say incorrectly, that she wasn't obliged to plead her case in advance of the trial and seemingly in advance of submissions. And can I also deal with paragraph 178, which is the suggestion that the husband is in some way ambushed is unsustainable. He cannot be ambushed by the revelation of his own deceit. And we say that that is fundamentally, that assertion by Sir Jonathan was fundamentally flawed. And as the case law makes clear, and I can do no better than really to take you to our skeleton at page C30, the core bundle, page 36, where we deal with that at paragraph C, and I'm just going to let you read that if I may.
Certainly. Sorry, what paragraph was that again, Ms. Wangate, please?
Paragraph 36.
Thank you.
Page 36, paragraph C. In any event, it was the wife's case as advanced in closing submissions. It was about not that the husband had perpetrated a deceit in drafting the first and second draft letters, but that such letters were true. Accordingly, we say the reference to the wife relying on the husband's own deceit is a mischaracterisation of the position.
Well, weren't the letters deceptive in other respects?
They were intended to deceive. They were never as...
The difference between deceptive and intended.
Well, it's a bit... I think Mr. Richardson used a rather elegant phrase during his submissions at the trial, which was that it was a lie that wasn't in fact told. So these were two documents that were prepared to be used to big up the bank's balance sheet, but they were never actually shown to a third party.
I might ask you or someone then, not this minute, just to take me some references, because probably it must have been in Mr. Hussain's evidence. I sort of got the feeling that the letters may have been shown, but they never really got off the ground.
No, because neither bid for the banks, and I have to be careful because you've refused my application for fresh evidence, but neither bid for either entity that had been in prospect was pursued. And so they were never shown to a third party.
Oh, okay.
And what...
I must misremembered that now, I apologise.
What in fact happened was that the deal was done with the Horse Akbar, and please don't ask me to explain it, that would be Mr. Will if it needs to be explained, had the effect of bolstering the bank's balance sheet by 21 million, so the letters weren't needed, had they been needed to pursue those bids. Right. So they weren't actually shown to a third party, excluding, we say, the wife. So may I now turn to do with the cross-examination of the husband and how the wife put her case. And it perhaps I might just take you back to TUI, which is tab 21 of the authorities bundle. Paragraphs 42 and 43 at page 687. And just to remind the court of the requirements set out at paragraphs 42 and 43, which I think we looked at earlier. And then in particular, can I take the court please to paragraph 70, which is at page 697.
I think we looked at that as well, didn't we?
Yeah. I'm so sorry, my lord.
We looked at that this morning as well.
Yes, paragraph 70.
Yeah.
So what we say is that in general you're required to challenge evidence in cross-examination, and in the present case, insofar as the wife wanted to put a case at the husband that the letters were genuine and evidence of an account, that had to be put to the husband in cross-examination, and in respect of the second letter, that the wife should have recalled him to put that allegation squarely to him. In fact, the only allegations we will see that were put to the husband was that, one, the letter was dishonest, and two, it was a sham. And may I start on the transcripts at the supplemental bundle at page 216 at C2E. So it's John McGowan, the intention was to make the bank look more solvent or liquid than it was. It was the point to do so in order to support the bid process, yes my lord, but that's dishonest. You may describe it as being dishonest, Mr. Glazer. Well, it didn't have that money, did it? What was it? What it was a structured transaction in order to prove a possession objective. Mr. Sultan didn't have that money. Mr. Sultan, it didn't have that money, did it? So that was the thrust of the cross-examination by Mr. Glazer. And then we move on to 218, please. At paragraph D.
Do we have to miss out, because the judge, this cross-examination, so it's causation, because it's slightly got out of hand, for one reason or another. You accuse Mr. Glazer of bullying your client, and then the judge takes over, doesn't he?
Well, he does.
At 217.
Yes, but in 218, I'm trying to deal with what Mr. Glazer put.
Yes, but shouldn't we look at what the judge says at one point, was trying to diffuse the situation in Council Row by saying, the judge said it's probably not helped by me and Mr. Glazer asking questions at the same time. That's the judge calming you all down.
Yes.
And then the judge asks questions about this very point, doesn't he, on 217?
Yes, he does. He says, but this deception, because it does seem to me to be a deception, was a deception not only on any regulatory authority, but presumably a deception on the auditors as well, And my client says the account never existed, and if it did exist, it would have been offset as a liability.
Yes. There's also an exchange between the judge and the witness above that, in which looks as though your client may have said, so Myrna's inaudible letter, Myrna saw the letter. Is that
Yes.
what you're saying? That's why I say I think that's all we need to do the whole thing, rather than just don't miss out what the judge asked, because that's part of the questioning, isn't it?
It is, but I was focusing on Mr. Glaser. I will try, where I've highlighted if there's any questions from the judge, to also include that. Or I'll get Mr. Wheel to nudge me if I've left anything relevant out. Can you do that? So if we go then, please, 218 at D. But Mr. Sultan, it didn't just deceive the auditors and the regulators. You go on in paragraph 231 to say top of page 1 by 1. And secondly, it allowed us to present the account as affecting sufficient funds to support a base we made to acquire another bank. So you also lied about the solvency of this bank. So you say to support a bid for another bank. And Sir John Lincoln said, was there ever a bid for another bank? And then Johnson said, that's not quite an answer to the question. Was there a bid for another bank? And it said a bank that was owned by the Portuguese bank directly. So the sales process started and then it stopped, and it never proceeded to the point where.
Reading on, isn't Mr. Glaser putting to the witness, or the inference, or the implication, whichever it is that there is an account?
No, he's saying it's a dishonest letter, and there was never. Can your lordship just bear with me? Because what he does, he culminates in suggesting, in putting repeatedly to my client that the letter was nothing but a sham. There was not one suggestion by Mr. Glaser to my client, and I can say this with absolute certainty, that this account was ever genuine.
Well, I wonder what the question at the bottom of 218 and over 219 means. In answer to your client who said the account never existed at letter G, Mr. Glaser, well, this is Mr. Glaser, not the judge, isn't it? Mr. Glaser, let's look at your language, shall we? Because you're very precise about the words used. Let's look at the language in 231. Do you accept the language used in the first sentence? The only fair reading of that is that you have another account.
Yes. And he has suggested that is and my client says yes, it clearly gives that impression.
And he then says that's not the impression, the clear meaning of that language.
Yes, but he doesn't put to him that it is a genuine account on no occasion throughout this. And as we will see if we follow this through, and you might just have to bear with me, that it culminates in him suggesting repeatedly that the letter was a sham. And I don't know if your lordship has picked up on those claims, because this is early on in the cross-examination.
But didn't the judge go to some lengths to clarify exactly what the situation was, and the passages going all the way up through to page 223 in the fund?
Yes, he did.
Because with all respect to the questions and answers, without the judge clarifying it, there was a swirl of different what did, what didn't, what might, what could, what was intended, what happened.
Yeah, it's essential page 223, your lordship is right, where Sir Jonathan says, there never was an account. And my client answers, there was never an account.
Yes. And that is after several pages where the explanation, such as it is, was proffered in response to a wide number of questions about it.
Yes. Let's be blunt. My client.
Is that right? Though?
Yes.
Mr. Glaser was asking some of them, and then at one point the judge tried.
Yeah, there was a bit of a tag team. But can I be blunt? My client somewhat went around in circles in his evidence.
Yes.
He would have helped himself much more if he had been entirely upfront about the letters. I can't get away from that. But my golden point, as it were, is that it was never put to him that he wasn't, well, 2 points. One, he was consistent throughout, that this was not a genuine account, that it had not existed, and that it was put to him that the account was a sham. Now, if we go, please, to...
I think it goes on for really quite a long number of pages, doesn't
it? It does, my lord. And...
all the way to 225 at least.
It does, but if needs be...
Well, Miss Bangay, I noticed the time. It may be that we can read through.
Can I just take you to what I say is, from our perspective, the purple passage, or two of them, page 236.
Wouldn't it be better if I say so, if we read the whole thing and then you did that?
It would.
For my part, I think I want to, in the light of what you said, I want to reread again my Lord's comments.
Will you have in mind page 236?
Yes.
Certainly.
Well, 233.
We'll read all of it and then you can highlight it.
Thank you. I hadn't realised the time, I'm so sorry.
No, I don't think any of us had. Well, Lord Justice Baker had. He's obviously hungry. Very well, thank you very much, Miss Bangay. 2:05.